Welcome back to the International Nuremberg Principles Academy, broadcasting from Nuremberg, Germany, The Hague, the Netherlands, Nairobi, Kenya, and Lakewood, New York, USA. We are pleased to co-host this event on the 75th anniversary of the International Military Tribunal judgment with the Robert H. Jackson Center. Before I hand over to the director of the Robert H. Jackson Center, Kristen McMahon, I will ask all the speakers to mute their microphones until they are addressed directly. There will be a recording of this event posted to the Academy's YouTube channel and linked to our website. Without further ado, I pass the floor to Director McMahon. Thank you.
Thank you very much, Jennifer. I'd like to thank Klaus and the entire team at the Academy for co-hosting these discussions with the Jackson Center and for hosting a very small contingent of us here in Nuremberg in person. We thought it important to commemorate the 75th anniversary of the International Military Tribunal and the judgments to help ensure these conversations and these learnings and teachings continue. The work the Academy does to promote sustainable peace through strengthening justice and the rule of law, and the work the Jackson Center does to promote the universal principles of equality, fairness, and justice through education on the legacy of Justice Jackson and the rule of law are every bit as necessary today as they were 75 years ago. Our organizations and the work of all those who are strengthening human dignity and human rights, shining a light on, gathering evidence of, and prosecuting the perpetrators of war crimes, crimes against peace, and crimes against humanity are even more crucial today as the memories of the International Military Tribunal and its verdicts fade. Yesterday, when we discussed the IMT judgment as precedent for the evolution of international criminal law with some of the legacy prosecutors, and today, as we will hear from the current prosecutors about the implications of the judgment today, I think those of us who do not live in or practice in this world regularly are more able to see clearly the through line and how they can be carried forward. I want to note that Justice Jackson recognized the impact of the IMT at Nuremberg would require time and perhaps significant time to develop. He stated that the results likely alone would not be enough to prevent future wars, but he did think it would put to rest the concept that all wars are just and legal. Nearly 3 years after the IMT judgment, he reflected and said those who gave some of the best efforts of their lives to this trial are sustained by the confidence that in place of what might have been mere acts of vengeance, we wrote a civilized legal precedent and one that will lie close to the foundations of that body of international law that will prevail when the world becomes sufficiently civilized. I suspect at least some of our esteemed panelists would say that the world has not yet become sufficiently civilized, but the precedent of the IMT and the Nuremberg principles themselves are keystones to building towards that. So thank you to all of our panelists for continuing this important and challenging work and for teaching the next generation. You are the living embodiment of Justice Jackson's international humanitarian law legacy and the Nuremberg principles. To conclude with a compliment from Jackson, you are members of a worldwide profession whose quest is justice and whose guide is law. Klaus, I'll turn it over to you.
Thank you, Kristen, and thank you, Jennifer, for your opening words. And welcome back, or welcome to all speakers and to the audience from near and far, Europe and the Americas and other continents. Welcome to the International Nuremberg Principles Academy. My virtual background today, as yesterday, is Courtroom 600. That's the place here in Nuremberg where it all began, where the first trial ever in the history over main perpetrators of war crimes and crimes against humanity as individuals was held. And it was exactly 75 years ago, on 30 September and 1st of October in 1946, when the judgment of this first trial was rendered. And we commemorate this historic date. I'm not going to repeat what I said yesterday, but it is important for the context that this judgment is the cornerstone of everything. And it spans now 75 years until today, what happened after the judgment in the field of international criminal law. There was a long, actually a way too long, period of silence before 47 years after Nuremberg, again, an international tribunal was established, this time by the United Nations Security Council. Other courts followed, and one of the most remarkable milestones, of course, is the creation of the International Criminal Court, a first permanent court whose mandate and activities are directly linked to the Nuremberg Principles, which in themselves were developed from the Charter of the Military Tribunal and the judgment we remember of today. Yesterday, we heard and saw some of the pioneers of the rebirth period of international criminal law. Among them, the first prosecutor appointed to an international court after Nuremberg, the first prosecutor who indicted and tried a head of state, and the first female African prosecutor ever appointed to an international court or tribunal. Today, we have the honor and the privilege to have with us the prosecutors who are carrying the mandate in today's international courts and tribunals. And we are very honored, and I would warmly welcome them all, starting with Dr. Karim Azad Ahmad Khan, Queen's Counsel, Prosecutor of the International Criminal Court. He was elected as the third prosecutor of the ICC on 12 February 2021 and sworn in on 16 June of this year. Karim was an Assistant Secretary General of the United Nations and served as the first special advisor and the head of the United Nations investigative team to promote accountability for crimes committed by Daesh or ISIL, UNITAD. It's the abbreviation from 2018 to 2021. He's a barrister and a Queen's Counsel with more than 25 years of professional experiences in international criminal law and as a human rights lawyer. He has prosecuted, he has defended, and he's represented victims before all, as far as I see it, currently existing international criminalized jurisdictions. A bencher of Lincoln's Inn, Karim was appointed a recorder of the Crown Court in 2018, and he was elected the second chair of the ICC Bar Association in July 2017. Today is worldwide ambassador of the African Bar Association. Karim has published extensively, and he holds so many academic degrees and awards that he will forgive me that I don't list them all here, but he is one of the most renowned persons in the field that we have today. I also welcome Dr. Serge Brammertz, the prosecutor of the United Nations International Residual Mechanisms for Criminal Tribunals. Serge was on 28 November 2007 appointed by the United Nations Security Council to serve as the chief prosecutor of the International Criminal Tribunal for the former Yugoslavia, the ICTY. And in 2016, he was appointed by the very same body to serve concurrently as the chief prosecutor of the Residual Mechanism for Criminal Tribunals, a position that he held until today. Serge Brammertz has been from January 2006 to December 2007 the commissioner of the United Nations in the independent investigation into the assassination of the former Lebanese Prime Minister Rafik Hariri, over which later on the Special Tribunal for Lebanon was established. And Serge also was the first deputy prosecutor of the ICC, serving there from 2003 to 2005. Prior to his international appointments, Serge Brammertz served as the head of the Federal Prosecution Service of the Kingdom of Belgium. He is, and I'm proud to say that, a member of the Academy's Advisory Council. I welcome very much Norman Farrell, prosecutor of the Special Tribunal for Lebanon, appointed to this position in March 2012. Before that, Norman was deputy prosecutor since 2008 at the ICTY, and he was also the head of the appeals section and the senior appeals counsel from 2002 and 2003 at the International Criminal Tribunal for Rwanda. He held the same post at the ICTY until 2005, and previously was appeals counsel there from 1999 to 2002. After being the head of the appeals section, Norman was appointed principal legal officer at the Office of the Prosecutor and served from 2005 until his appointment as deputy prosecutor. Before his involvement in international law, Mr. Farrell prosecuted cases in Canada and argued cases before the Ontario Court of Appeal and the Canadian Supreme Court. I very much welcome in this round Dr. Peter Frank, the Federal Prosecutor General of Germany, who serves in this position since October 2015. He has a long career in the German judiciary. He served as a public prosecutor in Munich, held various senior positions as prosecutor and a judge, including in the Ministry of Justice in the Bavarian judiciary. Among those positions, the one of the Prosecutor General at the Court of Appeals for the Munich region. And I'm very proud to say that also Dr. Frank is a member of the Academy's Advisory Council. I very much welcome James Johnson, prosecutor of the Residual Special Court for Sierra Leone. He's the former chief of prosecutions at the Special Court and joined the office of the prosecutor in 2003 as a senior trial attorney and later was named chief of prosecutions in 2006. After he left the Special Court in 2012, he served for 3 years as president and chief executive officer of the Robert H. Jackson Center in Jamestown. So James, it's fair to say welcome back home to some degree to an event co-hosted by your former organization. Since 2013, he serves as a professor of law and director of the King War Crimes Research Office at the Case Western Reserve University School of Law in Cleveland, Ohio. And prior to joining the SCSL, James served for 20 years as judge advocate in the United States Army. And last but certainly not least, I welcome very much Alex Whiting, Deputy Prosecutor of the Kosovo Specialist Chambers and Specialist Prosecutor's Office in The Hague. Alex is also a visiting professor at Harvard Law School, where he teaches, writes, and consults on domestic and international criminal prosecution issues. He was at the Office of the Prosecutor at the ICC from 2010 until 2013, where he served first as investigations coordinator and later as the first prosecution coordinator, overseeing all the ongoing prosecutions in the office. He was a senior trial lawyer and a trial lawyer at the ICTY for 5 years from 2002 to 2007. And before coming to the ICTY, he was a US federal prosecutor for 10 years, first with the criminal section of the Civil Rights Division in Washington, and then with the United States Attorney's Office in Boston, where he focused on organized crime and corruption issues. Much to our regret, the only currently serving female international prosecutor, Dr. Brenda Hollis, the international co-prosecutor of the extraordinary chambers in Cambodia, is not with us today. Urgent court proceedings have forced her to withdraw from this panel, but she sends us all her very best regard. This distinguished panel is moderated by Janet Anderson from The Hague. She's an international journalist and independent consultant and has been covering international justice in Rwanda, The Hague, Sierra Leone, and Uganda for several decades. She trains and supports locally based journalists in covering atrocity crimes trials and has authored several manuals guiding journalists and monitoring their work. She's the vice president of the Association of Journalists at the ICC, and she co-hosts Asymmetrical Haircuts, a podcast offering a side-way look at international justice, interviewing mainly female experts in their fields. We are most grateful that you all have accepted our invitation, despite your notoriously overloaded schedules and agendas, to reflect together on the Nuremberg judgment and its relevance and impact of today. And without further ado, I hand over this discussion to Janet and the panel. Thank you all very, very much for being with us. Janet, the floor is yours.
Thank you very much, Klaus. And thank you very much for that long, extensive, great introduction to everything here. You did all of the heavy lifting by explaining who is who. So there's nothing really left for me to do apart from to hand over to our illustrious speakers, who, as Kristen said, quoting Robert H. Jackson, you guys are the living embodiment of the work that was being done in Nuremberg. So no pressure on all of you. I want to know how you're going to live up to this in the discussion. Just before we start, I want to let the audience know that we had asked the panelists to prepare a few remarks to start with. These are a few minutes for them to reflect on the Nuremberg judgment in relation to their work now. So there could be continuation, there could be contrast, there could be elements that they think are important to raise. Thereafter, we're going to try to get a bit of a conversation going between people. The question and answer box is open here in case you have any questions from the floor yourself. But I think that the best thing now is to get the ball rolling and to ask Serge Brammertz to kick off for us, please, with your comments on the subject of the day.
Thank you very much, Janet. Good afternoon, everyone. I'm very pleased to see some of my colleagues. I normally meet at least once a year in Chautauqua or other places. So at least I'm very pleased to see you online and to have a discussion with all of you. A few comments to start from my side. So I looked into some of the questions related to the selection of accused, selection of cases, selection of charges in indictments. What have been a little bit the lessons learned? What is the current situation? And as we know, and as this was already discussed yesterday for the IMT, the statehood focused very clearly on the major war criminals to be prosecuted. At the ICTY, which, as Klaus mentioned, started almost 50 years later, somehow in contrast, it was formulated more broadly in relation to the persons to be prosecuted by mentioning persons responsible for serious violations of international humanitarian law, giving more prosecutorial discretion to modern prosecutors somehow in this regard. We all know in our prosecutors, we have since ever this discussion about who to be prosecuted. And we all know that in the early days at the ad hoc tribunals, more mid-level or lower-level perpetrators were prosecuted. Later on, once we moved into the so-called completion strategy, the mandate was very clear by Security Council to say, we want you to concentrate on those who bear the greatest responsibility, and the other cases you should send back to the region. We all know that the similar tension, even if the mandate was more clear in this regard with the ICC, we know that the same tension was there with, at the beginning, a number of persons considered being more mid-level or lower-level perpetrators being prosecuted. I remember when I started in the international field, it was more often mentioned as a criticism than as a positive element. I think that if we reflect about it today, I'm quite convinced that a strategy of an international prosecutor should really integrate both aspects. Top down where possible, bottom up when necessary. And we have seen by having prosecuted a number of mid-level and lower-level perpetrators at the ad hoc tribunals, for example, we were much better prepared when later on cases in relation to Karadzic or Mladic were prosecuted. So my first point also for discussion is really to say, I think that there is some flexibility needed for a prosecutor, and prosecuting mid-level perpetrators at the beginning, establishing the chain of command can have a lot of advantages also, because in this group of persons that you are looking for your insider witnesses. Second aspect, very briefly, is the number of cases you can prosecute. ICTY, ICTR have been the tribunals dealing each with one situation, where the ICC has more than 20. We have at ICTY indicted more than 161 individuals, at the Rwanda tribunal more than 90. But still, it is more than all other international tribunals together, but it's very little if you look at the number of cases to be prosecuted. I was last week in Belgrade, where we had our annual meeting with the 40 war crimes prosecutors from the former Yugoslavia. And in Bosnia-Herzegovina alone, there are still 3,000 investigations ongoing, and where our role today as a mechanism is really to provide assistance to those national prosecutors. So where we were in the driver's seat for many years to conduct investigations and prosecutions, today we are mainly supporting colleagues in the region by transferring more than 200,000 pages of documents every year, by having liaison prosecutors in our office, by providing specific training, by transferring case files, etc. So I really think that knowing that international tribunals can only prosecute a very limited number of cases, the only solution is really as soon as possible to have an integrated approach between the international level and the domestic level in order to have impact. Last point, third point, very briefly, is really the scope of the indictments. Always a discussion, are we prosecuting one person, 5 persons, how big the case should be. We know in Nuremberg there was one trial, 24 accused, but we have seen that in modern times, this is almost impossible. At the ICTR, it was tried, and we have some colleagues who work there present today. Well, there was one indictment with 29 persons in relation to leadership cases. It was not adopted, it failed, because some of the persons were arrested, others were still fugitives. For some, the case files were already advanced, for others not, which also shows that having multi-accused cases at the international level is extremely complicated. We had several at the ICTY and ICTR, up to 6 persons, but obviously they present an important challenge. What worked in Nuremberg in this regard is not really working at international tribunals today, with a major problem being the lack of arrests. Last point, and I would say that's the most difficult, if not the most frustrating for any international prosecutor, is really the selection of incidents you put in your indictment. Because we have to deal with hundreds of incidents where hundreds, thousands of persons have been sexually abused, have been killed, have been displaced. And you have to make choices as a prosecutor. You cannot prosecute everyone, we discussed already, but you can also not prosecute for every single crime committed. We have seen in the Milosevic case the result by trying to put too many incidents into the indictment. I remember very well when Karadzic and later on Mladic were arrested, I reduced the indictment by almost 50% because we really wanted to find a better balance between crimes selected which represent the magnitude of the crimes committed in relation to ethnic cleansing, in relation to the siege of Sarajevo, in relation to the genocide in Srebrenica, but still having a case which remains manageable. And having met many, many times with victims' organizations explaining why certain individual crimes were reflected in the indictments, others not, it was always a very difficult exercise. And that's why in our case, we are so pleased to see that many of those cases we could not prosecute are now indicted at the national level. So case selection, selection of incidents is this other very, very difficult decision for prosecutors, where managerial aspects really make that you have to limit yourself in what you put in the indictment. I see that I'm already close to my time, so I leave my general comments on this, but of course I'm looking forward to our discussion later on. Thank you.
Thank you. Thank you very much for such interesting comments. Just to remind everybody, those were comments by Serge Brammertz, who was speaking from his experience of the United Nations residual mechanism for the ad hoc tribunals, the former Yugoslavia and Rwanda. And one thing that might lead us into our next speaker is that he talked about not being in the driver's seat necessarily right now, but having to support local prosecutions. Our next speaker is Dr. Peter Frank, and he is the German federal prosecutor, and they have some very interesting experience in Germany in taking forward prosecutions for international crimes. Over to you.
Yeah, thank you very much, Janet, to give me the floor. And first I want to say that it's a very great honor for me to be here in this discussion because I'm a German prosecutor, and this anniversary of the judgment of the Nuremberg trials is connected to the German, to that what German does in the Second World War, and so I think it's very great honor for me to explain and to discuss with you and to explain our strategy, what we will do or what we have done in the last 15 years in Germany for international criminal cases. First, I want to look back on the situation after the World War II. In the beginning of the Federal Republic of Germany, the judgments of the Nuremberg trials were not accepted. They were not accepted by the political. They were not accepted in the law science, and they were not accepted by the people, because in Germany the Germans can't reflect what happened in the World War II and what happened in the Nazi time. It was very difficult for them. Because it was the judgment was a very hard answer. That it was the answer that what the Germans had done in the World War II, it was not only a war, it was not only a political affair, it was crime, individual crime that everybody who's worked in the Nazi regime, not only in the government or in the very high level of the Nazi regime, so everybody of the German people who worked in this system, perhaps as policemen, or as a soldier, or they have always worked in the society, they were guilty on that what happened. They were guilty on perhaps war crimes. They were guilty perhaps on the genocide and other things. And this was a very hard answer. And the German people in the very young beginning of the Federal Republic of Germany they don't want to look back into history, what they have done. They want to look forward. And so nobody or only a few people were interested in that, what happened in Nuremberg. But this changed. This changed after the German reunification, because there was time to look back. And there are two reasons why they must look back. First, we have the regime in the German Democratic of Germany, in the East German part, in the eastern part of Germany. There was also a similar regime where people were killed when they want to cross the border from Eastern to Western Germany. And also there was the beginning civil war in the former Yugoslavia. And a lot of people from former Yugoslavia came to Germany. And so we looked, the Germans looked on these 2 points, and they changed their opinion about this topic. And so the Nuremberg judgments are now understood as a mandate to oppose the most serious international crime under criminal law. Nuremberg is for us, therefore, a permanent reminder that is our duty, that we must do everything that these things cannot be happened worldwide. And when it happened, so we must do something against it. So we must investigate and we must prosecute the perpetrators. And this is what Nuremberg is from our work and for the work of my colleagues. When we started after the Statute of Rome was implemented into German national law, we started in our office with, I think, 2 or 3 prosecutors to look on this very important topic. Now in my office, I think 40 or 50 colleagues, 40 or 50 prosecutors work on this field. And when we look back into this 40 or 50 years, I think it is a very successful way where we worked on this field. First, it was a beginning, I think, in the end of the 2000 years, it was a beginning because there were some leaders of a terrorist organization in the eastern of Congo, in Germany, and they were leaders of a terrorist organization, and this terrorist organization, it was a militia in eastern of Congo, and they tortured the people there. There was also an offenses against the people there, and it was that what we said crimes against humanity. And so this was the starting of a very successful story. And then after the beginning of the civil war in Syria, a lot of people from Syria came to Germany, victims of this civil war. And also we thought that that perpetrators come to Germany. And so we started in a very soon time investigations what happened in Syria. Not also what's happened by the jihadist terrorist organizations. We also started an investigation what's happened by the Assad regime. We had a lot of victims of the Assad regime in Germany. And so we collected a lot of evidence. These were witnesses. We collected this evidence and we started the first cases, the first trials, because we identified some people in Germany who were officials in the Assad regime, and we started the first trials against members of terrorist organizations like IS or Daesh or Al-Qaeda, the Nusra Front, and other terrorist organizations. Because people from Germany went to the Syria to the Syria civil war, and they fight there in some organizations, and they come back, and also refugees come to Germany. And so this was the beginning of the investigations in the Syria and the Iraq cases. And we have now brought a lot of people in Germany to court. And we have got the first convictions, or a lot of convictions against these people. And I want to say some other things. What is our strategy? Our strategy is that Germany and Western Europe can't be a safe refuge, not a safe haven for these perpetrators. This is our answer and our strategy of the Statute of Rome. Because we have got in Germany the possibility to have an universal jurisdiction, I can investigate for every crime worldwide in Germany. But we focused our investigations on people who are in Germany or in West Europe, because it's not. I think it's not a very good idea to start an investigation when nobody is in Germany. But when there are perpetrators in Germany, when there are a lot of evidence in Germany, so we started our investigation. And so it was also in the Chesedy case. Because the German government allows, I think, more than 1,000 Chesedys to come to Germany after the IS attacked these people in the northern of Iraq. And so we had a lot of evidence in Germany. We've got, I think, more than 1,000 young people, women, especially women and young ladies. And we want to have a discussion with her what happened there. And so we started our investigation there. And this was the basis. So we brought that in a lot of our trials and investigation and prosecuted files. And so we have got a lot of conviction. This is I think it's a duty for us to do that, because Nuremberg was the answer of that, what German does, the Jews and other people here in Europe. And so we are a strong partner to cooperate and to investigate this very serious international crime. But let me say another thing. It's not only not important that every country who has the Statute of Rome implemented in national law will do that. It's very important to have an international cooperation. And so for us, and from my understanding and the understanding of my colleagues in my office, is that it is very important to have this very close cooperation with the international courts, with the international prosecution authorities, but also with the national prosecution authorities I think in France, in Sweden, Netherlands, and other one. And it's also very important to have a very strong networking with the academic side of an interested side of this topic, and so also with the International Academy of Nuremberg to build up capacity worldwide to protect human rights And to bring this answer that if somebody violates human rights in this way, it is international crime, and everybody in this world will prosecute this crime. Thank you very much.
Thank you. Very interesting remarks there about the sense of duty in Germany from Germany's federal prosecutor, and some of the practical implications there in terms of the universal jurisdiction cases. I'm now going to hand over to Norman Farrell from the Special Tribunal for Lebanon for his comments.
Thank you very much, Janet. Thank you very much for the invitation, and it's a pleasure to be on a panel with the rest of the individuals here representing the work that we've been doing. If I could just start, I'm going to speak a little bit about the Special Tribunal for Lebanon and some of the overlap, though maybe less than the other courts that have jurisdiction similar to the crimes that were prosecuted in Nuremberg. But if I could just start, since we're actually both looking back and celebrating a truly significant event in international justice over 75 years ago, I wanted to start by a comment at the time about the Nuremberg Tribunal, and maybe not one that you would look to or think about when considering a reflection on the work of the tribunal. But on February 8th, 1946, after the USSR Chief Prosecutor Rudenko presented his case against Hermann Göring, at the lunch break, Hermann Göring was so upset that he said about the IMT, "You will see, this trial will be a disgrace in 15 years. Truly, he was wrong. He also, in his opening statement before the IMT, commented on something that we've seen many times since, not so much at the STL, but many others, where he commented on the fact, and this was on November 21st, 1945, that I am responsible for these acts only to the German people and can be tried only before a German court, referring to the fact that he cannot be tried before an international tribunal. Now, the Nuremberg Tribunal, there's many lessons to be learned, but there's many themes and common parallels that we see in many of the prosecutions today. Things such as Göring's statement about state sovereignty. And we still see that today in the prosecution or attempted prosecution in some circumstances of heads of state. Things such as functional immunity, personal immunity, heads of state immunity, even some of the decisions from the ICC recently and those historically from the other tribunals. There's many other parallels about individual criminal responsibility, jurisdiction, and accountability. What I'm going to comment on in just a few minutes now today is some of the things that arise and the overlap with the Special Tribunal for Lebanon. The crimes that we prosecute are not similar in nature to the ones that were prosecuted at the IMT. We prosecute terrorist crimes, the crime of a terrorist act, conspiracy to commit terrorism, and some domestic crimes under Lebanese law. But what does overlap are a number of the procedures that have arisen over time that started in Nuremberg. Not only the modes of liability, which is a form of liability that arose from Nuremberg and is reflected in our Article 3, and there's no defense of superior orders, another matter that arose and was codified in Nuremberg, but one that is unique to the STL and one that may have caused a lot of, well, let's just call it a lot of thought at the beginning, which is a trial in absentia. And the only reference to a trial in absentia prior to this at an international level was, of course, the Martin Bormann case before the International Military Tribunal. And that they proceeded against Martin Bormann on the basis that they were uncertain whether he had died under Article 12 of the Charter. And they proceeded, as the Charter says, when it's in the interests of justice to do so. That's fascinating. From a common law perspective, there is no such thing. From a civil law perspective, there is. This represents, as does much of the IMT, some of the merger between civil law and common law systems. And we still see that today. We still see trying to determine what works from one system and can be incorporated from another. I remember the first time I appeared before a German judge, coincidentally, at the ICTY on a case. And at the end of the case, after I'd made my final arguments, he turned to the prosecution and defense counsel and said, now we'll hear from the accused. Well, the accused hadn't testified during that part of the proceedings, and I was not, and neither was the prosecution, given the opportunity to cross-examine him. But of course, it was explained to me that the accused had the final statement. Just as what happened at the IMT, when all the accused were asked to speak at the end of the IMT, and they were given the opportunity to provide a final statement. Other overlaps relate when we think about Justice Jackson's comment about the need to try and put forward an evidentiary record that would stand the test of time. The types of evidence that he was considering was documentary evidence, other evidence that was objective. And some of the evidence that was used included video footage. There was the film shot by the US troops when they were liberating German concentration camps. And there was the 4-hour movie that was shown during the trial in Nuremberg called The Nazi Plan, which compiled various Nazi propaganda films and newsreels. Now, this introduction of what was perceived as somewhat non-traditional evidence at the time, and the reliance on documentary evidence as opposed to oral testimony, it was a bit of a precursor to what we face in many respects today. At this tribunal, the Special Tribunal for Lebanon, we have relied extensively not on witness testimony, but on data collection, telecommunications data. And we have reviewed over 11 billion records of data communication. Those are bytes of information to try and determine patterns of use of phones that can be used to demonstrate culpability. Now that's a long way from Nuremberg, but the concept of relying on some other evidence that you can point to that's objective, that's not witness testimony in times of conflict, is something that we're still struggling with today. What that means on the other hand, though, is if you don't call witness testimony as much, or if you try to put, for example, the death and suffering of a number of victims on paper, it's faster, it's more expeditious, it's usually not disputed. You may be criticized for removing the voice of the victims and their ability to speak during the trial, which is interesting in light of Justice Jackson's comments about one of the reasons he wanted to move towards objective or documentary evidence was to avoid the emotional side, which could be seen as tainting the evidence as not being objective. It's a tension. There's so many tensions that arose in the IMT that still continue today. Today, we are still left with a lot of those tensions that we're trying to resolve in the context of maintaining fairness, in the context of a merger of both civil law and common law systems, the same thing that was faced at the IMT, and the merging of these legal systems that confront expeditiousness, but fairness and hearing the voice of the victims. Well, let's just say we're continuing to learn lessons from IMT, and there are not any, I'm not sure we found all the solutions yet. Thank you.
Thank you very much for that. It's very interesting remarks about use of different kinds of evidence and the balance of the choices that have to be made by prosecutors as to what to use. Our next speaker is James Jones from I think it's from the Sierra Leone Residual Court. So I think it's over to you now.
Okay, thank you very much. I appreciate it. And I'd very much like to thank both the Academy and the Robert H. Jackson Center for bringing us all together here. Of course, the Robert H. Jackson Center holds a very special place in my heart, having been there as the president and CEO, and so it's good to see you here as well. And you know, I think as we're looking at the legacy of Nuremberg, you certainly have to ask if we would be here today, and if Nuremberg would have the legacy that it does have, if not for the influence of Robert H. Jackson. And so I very much appreciate the Academy and the Jackson Center for bringing us together. As Serge did, I thought I would like to talk a little bit about the legacy of Nuremberg on the selection of charges and how we move forward with the indictments. And I think the legacy, as we look to build our indictments in Sierra Leone, I think the legacy of Nuremberg Hill was very heavy and was very much a consideration as we tried to make some of those charging decisions, as Serge has referenced. And, Nuremberg is remembered as building an undeniable record of what happened. And, although there are deniers out there today of the Holocaust and the numbers and intensity of those deniers, unfortunately, seem to be increasing a little bit of late. But it's because of what happened at the IMT that it makes it very hard for those deniers, and it has built that record. And I think that weighs heavily when you're looking at what you need to charge on, do you have a responsibility to build that historical record of the conflict? Do you have a responsibility to show the full extent of the criminality of what happened in the conflict? And, of course, as any prosecutor will tell you, and it's very clear that, your charges are based on where the evidence leads you. And without the evidence, you of course can't and do not move forward. But when you have an overwhelming amount of evidence, how do you make that selection? When we look specifically at Sierra Leone, and you may recall some of the images coming out of Sierra Leone in the late 90s. You may recall images of children, babies, that have had their limbs amputated. The number of amputations and mutilations that took place to terrorize the civilian population was just unbelievable at the time, but it was true. You look at the widespread sexual violence in Sierra Leone, although probably not new, but certainly brought to light in Sierra Leone, the phenomenon of the bush wife, and which caused us to move forward with what we considered to be a new crime in the crime of forced marriage, and charging that. You look at the use of child soldiers coming out of Sierra Leone. Again, not a new phenomenon, but the systematic use of children and the creation of what was called small boys and small girls units, and often having children as they were taken from their families, killing their parents. And then, of course, you looked at the attacks on peacekeepers and taking peacekeepers hostage in Sierra Leone. So what was our obligation to try and reflect the totality of the crimes and the totality of the accused coming out of our conflict? And Nuremberg weighed very heavily on us when we thought about, how much and what's our responsibility to build a record of what happened in that conflict. And I'm not sure that this is the same responsibility that can exist today when we're looking at charging decisions, when the ICC is looking at charging decisions. And whereas in Sierra Leone, we were looking at one conflict, but of course, the ICC is now looking at conflicts, but yet many conflicts. And not only how do we decide what to charge, or how do they decide what to charge within a conflict, but what conflicts they have the ability to look into and move forward. We had to think about, how do you say no to the victims? How do you, if you're not going to charge a particular crime, or you're not going to charge a particular crime base, as Serge has mentioned, how do you explain to those victims that you're not going to get your chance to tell their story? And so the weight of Nuremberg and the record that Nuremberg built, I do think weighs very, very heavily on what we're doing today. How do you make a choice between charges? How do you make a choice between crime bases that you're going to move forward with charges on? As Serge mentioned, where they looked at the Milosevic indictment, We did the same thing with the Taylor indictment before we moved forward with the Taylor indictment, before he came into our custody. We reduced his indictment from 17 to 11 counts. We reduced the number of crime bases that we were charging, the number of locations that we were charging, all in an effort to perhaps streamline the trial and make it a shorter trial. And so the legacy of Nuremberg weighed very, very heavily, I think, in some of our charging decisions and how we moved forward. And I still think that exists today as prosecutors make selections on who are we going to charge, what charges are going to be brought, what crime bases are going to be charged. And so, and you know, when you think about it, when you think about the, you know, is there an obligation of a court to build that historical record? Well, the obligation of the court is to bring accountability. It's to bring justice. And what does that mean going forward? And how do you make those selections? And what are some of the other constraints, be they resources, financial constraints, and such that that impact on that decision? And I think perhaps a final comment, in today's environment, we may be able to look at what other potential avenues are there out there to build that record, to do things that a court may no longer have the ability to do that Nuremberg did. Can truth commissions somehow fill that void? Can NGOs fill that void? Can civil society step in and help fill that void a little bit? As well as the trend that you're seeing towards national prosecutions and the ability of national prosecutions to fill that void. So thank you. A few initial comments, and I look forward to further discussion on this as we go down the road here.
Thank you very much, and sorry for mangling your surname as I introduced you previously. So some interesting comments there about selection and asking, I think, a very good question that I hope we'll pick up again as to who fills the gap, because prosecutions can't necessarily do everything and fulfill everybody's expectations. Now over to Karim Khan from the International Criminal Court.
Well, thank you, Janet. Thank you, Klaus, and everybody at the Nuremberg Principles Academy. It's a singular honor and really a real pleasure as well to participate in today's august event and to join many friends to follow Serge and Norman and Jim Johnson and Peter, of course. I really think this is a tremendously important day. I think the interesting bit may come in terms of the questions that will come later rather than what I'm going to say right now. But I think it's important to recognize something that is obvious to everybody. Nuremberg was a landmark moment, but it started the beginning of a process that continues today. And that process is evidenced by the speakers that spoke before me, as well as the existence of the International Criminal Court. It set a framework of accountability that humanity had been craving in reality for ages, for hundreds of years. It was during the time of King John when the famous adage came that the king is under no man but God and the law. And whatever the defects and criticisms of Nuremberg, I think any objective observer will recognize that it was a very sincere attempt to protect certain values of civilization through the prism of due process. And the fact that we are talking about it 75 years later, and as Norman mentioned, it gives the lie to the boast or hope or perverted prayer of Göring that it would be a disgrace 15 years later. It's not a disgrace. And we owe Nuremberg a tremendous debt of gratitude. Those bricklayers, those legal architects that demanded justice we build, or we seek to build, upon their fantastic work. Of course, Nuremberg didn't work in isolation. It was followed by a range, in fact, a slew of different international agreements and conventions, the Nuremberg Principles in 1950, but the Genocide Convention of 1948, the Torture Convention of 1984, the Rome Statute, of 1998, and of course, the singular critical moment, really, of the convergence, happy convergence in desperately awful circumstances of political will that gave rise to the establishment of the ICTY and then the ICTR. And that march of civilization, that stubborn attempt to continue to hold on to values greater than us, that will survive our demise and help create some kind of cover, some kind of protection to our children and their children, continues in this forum. And I think the simple lesson of Nuremberg is that a few people who insisted on due process, Stimson, for example, prevailing on Truman as a local judge in a small town in the United States, not to give way to Churchill's preference to execution, it can make a difference. And again, the impact of that, the debt we owe to that decision of a moment that led to the London Charter and, in San Francisco and then the London Charter, is what so many people cling to in hope today for a better tomorrow. In terms of the principles, we all know the important principles: individual criminal responsibility, no defense of superior orders, the right to a fair trial. And we see when we look at domestic cases from Pinochet to Eichmann in their respective areas, both draw inspiration and very often clear jurisprudential authority from the legacy of Nuremberg, that there are certain basic obligations that we owe humanity, particularly military commanders and civilian superiors, but all individuals, and certain crimes that in any circumstances cannot be derogated from, cannot be excused really in any circumstances at all. I really liked very much, as I was flicking through some papers before the speech, one sees, of course, jurisprudence from, of course, the ICC, from the ICJ, the ICTY, but I was looking through this resource collection on Nuremberg principles. So it's really one of the many ways that the Nuremberg Academy does such fantastic work. And the list is, in terms of reference to Nuremberg, states in Argentina, Australia, Belgium, Canada, Colombia, Chile, El Salvador, France, Israel, Spain, United Kingdom, United States, so on and so forth. So its impact did not end in the city of Nuremberg. It really has spread. These ripples have grown in strength over the passage of time, rather than being diluted as one would ordinarily expect. And in my view, that is only because of the moral authority of the decision, and also the value, the timeless value that was being protected and was being pursued by Nuremberg, which is the value of human life, which is the value of belief, of worship, and to live one's life free from discrimination or persecution, regardless of any other factors. It was Judge Cansado Trindade of the ICJ that framed the Nuremberg legacy, and I'm just quoting here from some notes I took, as a critical step in the gradual awakening of human consciousness. I think that was a wonderfully eloquent way of putting it. Nuremberg judgment as a part of the gradual awakening of the human conscious. Judge Wald, of course, well known to those of us that have been in the ICTY, but sitting as a US Court of Appeal judge in Prince against the Federal Republic of Germany, recognized that it had international legal force to be reckoned with. The Finter case, Norman will know it very well, Canadian case from the Supreme Court, well known. Justice Corrie recognized that the judgment, quote, must carry more weight than any declaration on international law made by the courts of a single state. Judge Katzmann in the United States of America, Second Circuit in Humali, accepted that it was reflecting and crystallizing pre-existing customary international law. Nuremberg also, though, was a call to do better. We saw in the aftermath, Peter mentioned it, some of the disquiet in Germany, and subsequently some of the criticism of the departure from German law that was understood by German jurists and German judges at the time in terms of ex post facto law, gave rise to a positive protection recognized in the statutes of the ICTY and ICTR and the ICC, and in fact all of the courts that I'm aware of, as part of Custom International, in fact, protecting the nullum crimen sine lege principle. That's a real legacy, in fact, of a self-aware critique of where Nuremberg, one part of Nuremberg that led to certain disquiet. I think, again, despite all the advantages and the achievements of Nuremberg, there are lessons to be drawn from what it failed to do. In this day and age, who could imagine a court of criminal jurisdiction that did not specifically include rape as a crime against humanity? That was not even mentioned in the London Charter. And yet, because of the wonderful work, firstly, the wonderful heroism of the survivors, that's first and foremost, must be recognized. The courageous men and women that spoke up, but then the wonderful work of colleagues in the ICTY and the ICTR and the ICC, Special Court for Sierra Leone. Suddenly, we know the ugly, the even more hideous face of conflict, which includes far too often crimes of sexual violence and gender persecution. One could go on. I will move on in the interest of time. The Riodia case, of course, the arrest warrant case, again, went back to Nuremberg, the need for a permanent court. This interlacing jurisprudence, reinforcing one another, not in a way that was in competition, but in a way that was advancing a core human value that is owned by all, civil law or common law, Northern Hemisphere or from the global South. The other aspect of Nuremberg that should give us rise to pause for thought was, it was in fact, in some respects at least, an exercise of burden sharing. Because after the Nuremberg trial, the subsequent proceedings under Control Council Law number 10, of course, were under the national jurisdictions of the different victorious powers. And I think here, whilst it is different, there's a similarity. It was a recognition that justice sometimes is quicker, is cheaper, is more effective under tried and tested processes. And in the Rome Statute system, the principle being complementarity is one that we need to give ever greater weight to in terms of allowing justice to be closer to the survivors, closer to the victims, and in a way that reinforces the international legal order. And the way I've been putting it is that, it is a call for states to step up to their responsibility. And when states step up to their responsibilities, the court, the ICC and my office can step out. But there's no secret there. It's very clear what the obligations are. Those obligations are there in the Rome Statute, but they are the echo of the resounding, unequivocal message of Nuremberg. In terms of Nuremberg being a roadmap, of course, the crime of crimes, the crime of aggression, we now have, of course, it was a matter of great contention, and we see the form it takes in the Rome Statute and Article 15 bis in terms of the crime of aggression, but also an area for the future, perhaps, who knows? The fact that the IMT prescribed criminal organizations and made membership of those criminal organizations an offense. So will this have any future relevance to the development of the law in other fora, whether it's for corporations or whether it's for other basic norms? One thing is for certain, The law is not static, thank goodness. And the law that is being applied within the respective areas of authority of domestic states, such as in Germany that Peter Franke has so eloquently spoken about, or the Special Tribunal for Lebanon or Kosovo, or the residual mechanisms that Serge is in charge of prosecuting. We should be viewing this body of law being united at one point. I view very much that the ICC is a child of Nuremberg, but we have siblings. We don't have sibling rivalry. We should work as united families to advance the cause of justice ever more. The final comment, if I may, is that it's perhaps apt that it was the IMT itself that relied on the US case of Karim when it started its process to underline the principle of individual criminal responsibility. And only just recently, again in the United States Supreme Court, there was a case of Nestle and John Doe, where Nuremberg was again prayed in aid in relation to corporate responsibility. So we have, as jurists, as judges, as practitioners, a job to do to make sure the law is relevant by applying the law within the legal bounds, within the statutes that states have put in place. But I think we can be very proud to be walking in the footsteps of the giants of the past. And I think that is a moment for reflection and one of appreciation for what has been done. But it doesn't lessen the magnitude of what remains to be done in the future. Thank you.
Thank you very much. Some really interesting threads there that I hope that we'll be able to pick up. I'd just like to encourage all of the people who are watching, if you do have questions, please feel free to start putting them in to the Q&A section, because we just have one more speaker to go now. That's Alex Whiting, who's going to make his remarks. And then after that, I'm going to start asking different questions of different people. So it's your opportunity as the audience to ask questions. Over to you, Alex.
Thank you, Janet. Thank you to the Nuremberg Academy, to the Jackson Center. Thank you also to my fellow panelists. It's an honor to be on this panel with all of you, who I will now, following on what Karim has just said, consider you as siblings. I want to talk about, and my comments will flow in other ways from what Karim has said. I want to talk about the project of the International Criminal Law Project, starting with Nuremberg and to the modern tribunals, and how, as prosecutors, we can best contribute to that project. As we look back after 75 years to Nuremberg, to the Nuremberg judgment, it might seem that that tribunal, that trial was inevitable, that it was an inevitable follow-on from the crimes that occurred during the war. But as we all know, and Karim made reference to this in his remarks, actually that institution, that trial was highly contingent and almost did not happen. There was serious thought among the leaders, the Allied leaders, to simply executing the Nazi leaders once they had been captured and their identities confirmed. And it was only the vision of some of the leaders to decide that prevailed and that led to the tribunal and to the trial and to the judgment that prevailed and decided that having a trial to show the crimes, to prove the crimes before any punishment was essential. And the same is true for the modern tribunals. It could be easy to think that there's an inevitability to those modern tribunals and their creation and to the push towards justice. I'm reminded of the quote, "The arc of the moral universe is long, but it bends towards justice." We might think, well, it's going to get there. It's just a matter of time. But that doesn't really fully capture also how contingent
radically contingent those modern tribunals have been. The ICTY was created in 1993 only because certain political stars aligned, the end of the Cold War, and because certain people had a vision that harked back to Nuremberg, and because, of course, that the crimes that were unfolding in the former Yugoslavia reminded people of the crimes of the Second World War, reminded people of the solution of Nuremberg. And what we've seen since the ICTY with the ad hoc tribunals, the creation of the ICC, the ICC's operation in different situations, is that those efforts continue to remain highly contingent, and they depend on two things. They depend on the political stars aligning, political will, and on people having vision and courage and imagination. You need those two things. Where those things come together, we have justice, and where they don't come together, there's darkness. There's no justice. And so across the globe today, there are pockets, there are places where justice is occurring, whether it's in the international tribunals or in national courts, as Peter Frank talked about, and there are places where justice doesn't reach because there is no political will and no imagination. So how can we as prosecutors contribute to the creation of these institutions, to this project, to this the tribunals succeeding? And I think for me, I see two ways that we contribute. Of course, as prosecutors, we make speeches, we try to inspire, we try to encourage, try to cajole political actors to create the environment that makes this possible. But there are really two things that we can do to make it, to continue this project. The first is we have to prove the concept. We have to prove that this works, that this is possible. And this may seem obvious, but that we need cases. We need to show that investigations, prosecutions, trials, appeals, that those things are possible, that they can be done. And Karim invoked the image of the bricklayers. And I think that we are all bricklayers in that way, building up a foundation of precedent, which then serves to, which then is a basis for victims in the future to say, well, they had justice there, and they had justice there, and they had a tribunal there. Why can't we have that? And so by building that precedent, by showing that it is possible, we build the foundations for this project. And then the second thing that we do as prosecutors is we have to innovate and be creative and find new solutions. So, and that's and some of the other speakers have already referred to some of this. Innovation in how we collect evidence, whether it's the telephone evidence that Norm's court relied on, or it's different kinds of witness evidence, or it's photographic evidence, or cell phones, or it's evidence that's collected by actors on the ground. There's no one answer to this. There's no silver bullet type of evidence. It's going to depend on prosecutors, investigators being creative and thoughtful and thinking about new ways to try to prove that this is possible against all odds, because there's a lot of political currents that go against accountability. And this creativity and innovation extends also to thinking about new models for prosecution, whether it's new types of institutions. The court I'm at is a new ad hoc court, or thinking about how state actors, as Karim has said, as Peter has said, some of the others have spoken about how national actors can take up the responsibility of doing these cases. But of course, that happens when the international courts prove that they can do cases. The complementarity flows from proof of doing cases on the international level. That's the core thing that has to happen first. The second point I want to make flows from the first one, which is about proof of concept. And it also harken back to something about Nuremberg, and that is how short the trial was. It's, as we look back on that case today, it's remarkable that it took a year to try 22 high-level individuals for serious crimes. That could never happen today, and for good reason, because as Karim pointed out, the Nuremberg court, for all the remarkable things that it did, it fell short in certain ways, and in particular in some of the procedural protections for the accused with respect to disclosure, preparation, time to prepare, and so forth. So no trial could be that short, and we wouldn't want it to be. However, I think that the tribunals, the proceedings now have sort of swung into the other direction. And when I've worked in The Hague and I've left The Hague several times, and whenever I leave The Hague, what people say is, well, okay, that's really cool what you do, but why does it take so long? Why is it so slow? And I try to explain, well, it's really complicated and there's translation. And that's not persuasive. That's not persuasive to victims, to states, to people who want to believe in this project. That is not going to work. That's not going to succeed. We have to find a way as prosecutors to do better in that respect. These cases have to be quicker, more efficient. And what concerns me is that the length of time that these cases takes is become normalized in The Hague. It's a little bit, you get used to, there's an internal logic to these cases, and you get used to it. Well, it just takes that long. If these are it takes that long, and you fall into a routine. And it's only when you get outside of the bubble of The Hague that you realize that something's not right here. I think to prove the concept, to make this project succeed, this is a place where we have got to find ways to do better. It's not just on the prosecutors, it's on the whole process. It's everybody has to contribute to this. And it's not easy, but but we cannot succeed unless we do these cases. We do cases, we do them better, and we do them faster. Thank you.
Thank you. And thank you everyone for your really interesting contributions. There's so many different threads to potentially pick up here. I'd like to ask all of you to start to think of anything that you'd like to say in response to what others have said, so that we can start the conversation. But before that, I just wanted to put one question myself to all of you about what is, I think, the elephant in the room. You're all men to start with. We have unfortunately not got Brenda Hollis with us, so we're lacking that. But even if she were here, that would be one woman with all of these other men. You're all from the global north, albeit Karim with some roots elsewhere as well. Is this international criminal justice project actually representative of the whole world? Or is it something that it is being done by a small group of people against other people? Would anybody like to pick that up?
Well, I'll perhaps go first, if I may. The panel, of course, is not representative. But international criminal justice, you mentioned, the last prosecutor of the ICC was from Africa. There's a co-prosecutor in Cambodia. There's also Cambodian. There is this, greater movement, and I think greater realization that partnerships with national stakeholders, with people from the region, but also geographic and gender equality, translates itself not only in terms of general fairness, but improves the quality of work. I think the easy cop-out is, if you look generally, I mean, today, before this, there was the new session of the International Criminal Bar Association. The new elected president is a Francophone French lady after 3 men. If you look at the composition of the bar generally, but also lawyers, we're getting, because of the historical legacy of really discrimination, that was really disadvantaged generations of women. I think that is beginning to change, but a lot of work needs to be done. And in my office as the prosecutor, I've said it very openly before my election. The directors are all male. Most of the senior trial attorneys I think 7 are male, 1 is female, but these are issues that we will get to. And certainly when my list becomes public in terms of we've gone through the process of deputy prosecutor interviews, I hope I will be able to fulfill my pledge. In fact, it was a prayer, but also a pledge that there will be a list that's entirely of females. So it's definitely work to be done. We can't be complacent, and we need to be determined and keep talking about it. So for that, Janet, I thank you doubly for the question.
Thank you. Serge, I think I saw you were briefly unmuted. Did you want to also comment? Or was that an accidental unmute?
Yeah, no, indeed, of course, I agree very much with Karim. When I was deputy prosecutor at the ICC, we're really representing the 3 of us, the prosecutor and the 2 deputies, 3 different continents. Of course, we all have every day to work on this issue. When I started at the ICTY in 2008, the situation was very, very similar, with mainly male, white, European or Americans in leading positions. Today, I'm pleased to really say that in my office, we have still the mechanism in total more than 50 different nationalities. We have gender parity, 50% at all levels, at the senior level P5 to the junior level. And the majority, of course, of our team in my office in Kigali and in Arusha, of course, are colleagues from the African continent. So I fully accept the criticism you express in relation to the members of the panel, but I also think that a lot of progress was achieved and that there is very, very strong awareness with all of us. And as I said, we are very proud, for example, in the UN system, in the UN family, to be one of the UN offices with the best gender balance in this regard. And it happened based on the qualification or the selection of the best qualified persons by making sure that the panels are composed by persons from both genders and coming from all regions. If you start having working on the panels, you automatically are coming out, I think, with results which are also much better reflecting the elements you just mentioned.
I saw Peter, Frank, you had also unmuted yourself, and then after that, James.
Yes, thanks, Janet. First, I want to say something to the gender question. I'm not representative for the prosecution team in this field. We have got, I mentioned before, we have got, I think, 40 or 15 prosecutors in this field. We have got 2 sections. We call them S4 and S5. These, I think, half and half, male and female. One of these sections is led by a woman, and one of these sections was led by a man who is now the new chief of UNITAD in Baghdad. But I think they are both male and female. But I want to focus on another question you had. I think it's not a question for me, because I'm a national prosecutor, and so I'm a national German nationality. But first I want to look on another point. It's not so that we only prosecute against, I think, Syrian citizens or Iraq citizens or African citizens. I mentioned before in my intervention that at the beginning of the Syrian civil war, a lot of people from Germany, Germans, or people who lived a very long term in Germany, went to Syria. And they went to one of these jihadist organizations, and they've supported these jihadist organizations, Al-Qaeda or the Daesh. Men and also women went to Syria. And so also these people, German citizens, when they come back to Germany, they are also suspects of our investigations. And we accused a lot of them. So it is not only to say that we, from the northern part or the European part, look on this field that the perpetrators are all from Africa or Asia. No, we have got also perpetrators of war crimes and crimes against humanity from Europe. And it's our duty to prosecute against and to accuse also our own citizens for our national cause or perhaps for the international court. Okay, thank you very much.
James.
Okay, thank you, Janet. I'll just speak very briefly. And really my comments are looking to the future. And of course, I think that we're looking here at a very male representation on the prosecutors. Fortunately, I think when you look at the registrars and other organs of the court and the chambers and the judges, and I think you see we have 2 female registrars at Sierra Leone, at Kosovo, and so on. But when I say I'm just like to comment looking for the future, I have the position where I can kind of look at being a professor at Case Western Reserve University and looking at the young men and women that are coming up in this field. And Case also has a large international student body from all over the world that are specializing in international law. And I look at the numbers of young women, and in some instances, I'm seeing many, many more young women than I'm seeing young men that are coming up in this field and that are going to be the future of this field as we go forward. And so, that gives, at least I hope that gives hope that, as we try to fix this gender imbalance, that moving forward, there's light at the end of the tunnel, I guess is what I'm saying. But thank you.
Thank you very much. Now, let me ask if anybody would like to comment back on something that somebody else has said. It was a while back, but I found Serge's comments on prosecutorial discretion about how this need to be flexible reflected back in some other comments. Would anybody like to pick that up, or maybe there's something else that you would like to comment on yourself, Serge?
If you like, I would like to comment on what Peter said, and we should probably have let him explain even more, the context in Germany in which the trial took place and what happened in the conscience of persons in the early years and how people are looking at it today. If you ask me what is my biggest frustration today in my job is to see in the former Yugoslavia the glorification of war criminals, the denial of genocide, to see that many political parties are very proud to welcome in their ranks someone who has been convicted in The Hague for war crimes, where student buildings are called after Radovan Karadzic, or where Mladic is, appointed or elected honorary president of organizations. This is really what we see is the biggest problem from Yugoslavia, where we see in Bosnia alone that you go to a Bosnian, a Serbian, or Croatian school, you will have 3 different history books with very different stories about what happened in the war or not. When you have the Minister of Education in Republika Srpska saying we took all reference to the genocide in Srebrenica or all reference to the siege of Sarajevo out of the history book because it never happened, I think we have a problem. So one of the big challenges for international tribunals, definitely when justice is served from abroad, far away from the different communities, is really to be understood, to be accepted in the communities. This definitely, and this is definitely, I think, where Germany has done obviously a better job as a society. Where I see in Rwanda as well a very different situation, where I think the government has, in terms of reconciliation, done a better job. But where we see today that in fact the quality of regional cooperation between prosecutors is today worse than 10 years ago, despite all the prosecutions at the international level and despite all the prosecutions at the domestic level. You are muted.
Apologies. Karim and then Norman.
Thank you. I was just following on. I think Serge has made a profoundly important point, if I may say so. It is really troubling that after trials, any individual could possibly glorify people that have caused such pain to so many And I think maybe we should also look a little bit beyond the courtroom. You know, trials are televised, of course, but anybody who goes into the Holocaust Memorial in Washington, D.C., in Berlin, or anywhere else around the world, you have crystallized for you both Nuremberg, the findings, some of the evidence, and the reality of pain, that people were heartbroken because of these acts. So how, when you leave, you feel with this such mixed emotions at both the heroism of survivors, but how obnoxious were the crimes that were committed by individuals. And I think maybe what we should try to do a little bit more of is to tie up the judicial process at the end of the judgment or the appeal, or even before, with such Holocaust kind of memorials or museums. I mean, I used to say in Iraq, in my previous function, that Iraq needed its Nuremberg moment. And early on, in fact, in my first year with the president and the prime minister, I gave the idea of, you know, both partnership with the Nuremberg Principles Academy and having some kind of, premises in Mosul that could preserve this evidence, because then children and next generations will repudiate the ideology very often and the thinking, the wrong-headed thinking that gave rise to that gave space for these kind of crimes to take place. So that was my only intervention on that point.
Janet, I'll just go next, if that's okay. And then I know that Serge referred to Germany, so I presume that Peter might want to follow, so I don't want to jump in. Just a couple points that I thought I'd mention. First of all, the question of the importance of the factual narrative of judicial decision-making is something that I think it's probably a little too early to tell, but I share completely the frustrations that Serge does. One thing we saw here, we're a trial in absentia. We don't even have an accused. It's not like we prosecute the accused and then we're worried about what they're going to do after, in which they might diminish the value of the judgments. We don't even have them present. But one thing the victims have continually said, and this is a much more narrow scope than Serge's and Karim's comments, which is that they've said that when they heard what happened on the day of the assassination of Rafi Hariri, they told us that they would have never known that the people who are carrying out the assassination using their mobile phones to travel around and surveil Hariri before the assassination. Some of them said they passed right by my house and I had no idea. And I never would have known under the current judicial system that would have brought them to justice nationally. So there is still some value. I think the other members of the panel would agree. It's the broader question. And I think that comes down a little bit to the expectations of the court. And this is the tension between what role do we play as international courts? Are we truth-seeking? Are we simply accountability for individuals? Do we have a role in the narrative of the country in which the conviction or the crimes originated? And that's a very interesting question. It's obviously not something I can answer or we can answer here, but the issue about the role that we play outside of the courtroom as an institution and the impact we have, we look back to Nuremberg and see the importance that it played and how these courts are the living embodiment of that expectation. And sometimes I wonder whether or not we can live up to that expectation, especially in some of the conflicts we're speaking about today. Thank you.
Okay, Alex, you had your hand up.
Yeah, just to follow on from this discussion, which is, I think, super interesting and important. I think, of course, we're living in a kind of post-truth world, right, where truth itself is disputed, and as Serge and Karim pointed out, and Norm also, it's frustrating to see war criminals be lionized and worshipped. But to me, that what I draw from that is that our work is all the more important in that world, because the thing we do is we dig down 30,000 feet on a case to establish the facts and drill down. And our job is not to establish the facts of the conflict. Our job is not to write the history of the conflict, but our job is to establish as best we can the truth of the case that is before the court. And that contributes to the history, that contributes to the legacy. As Karim said, that can lead to to monuments and remembering and certain truths being established. And the way we do that as prosecutors, as criminal prosecutors, is unlike anything that anyone else does. That is unique to us. And I think that is more important than ever now when truth is in dispute around the world.
If it's okay with everybody, I'd like to pick up one of the questions that has come in on the from people who are writing their questions in. This is from Sophia Atsupadi, and she refers to the potential development of an ecocide crime, and wondering whether, looking at the future that has been laid by the Nuremberg trial, do you think that international criminal law can deal with environmental destruction and its impact on human societies? I think this is something that we're all going to start looking at. Norman, you have your finger up.
Just a few comments. This may more readily fall under Karim's area, since there has been some discussion, I know, at the ICC, but just a few comments. There was a report, I understand, in June of this year, just a couple months ago, on an independent expert panel for the legal definition of ecocide, in the hopes that it could be put forward as an amendment to the ICC. And I think this is highly important, and I think that hopefully in time, I leave this obviously to Karim or others to determine whether or not that would fall under the jurisdiction. I think this is valuable. It's a fantastic question, but the issue that one has to think about, and not to make it into a strictly legal analysis, but something needs to be done soon. I think that's the import of the question, and something needs to be done about something that is a crucial matter. And unfortunately, law takes time. An amendment to the ICC statute, others would know better than I, will take an incredible period of time. Secondly, ecocide has not really been defined yet. So it's hard to imagine a prosecution of something where there's no definition in law. And it's certainly not a definition under customary international law. And about debates whether to criminalize it have been in the draft code of crime against peace and security and mankind in the past. And I think in parallel, and I know others have stated this, not just I, but I think this is so important that we have to put time and energy into, the extent that we can, and to the extent that we have laws that we might be able to rely on, using crimes against humanity for inhumane acts as a possibility, extermination, infliction of conditions of life, the war crime sections under the Geneva Conventions that apply to environmental crimes. They're very limited, I would agree. But I think if we've got to start somewhere, because I think this is a really important issue, and we should start with what we have and build towards, hopefully, a crime of ecocide or something that might be defined and accepted. Because ecocide also, these environmental crimes, they're extraterritorial. They pass across borders, and they don't occur in wartime, which is a lot of the matters that we deal with as international prosecutors. They occur in peacetime. So there's so much that has to go into it, but it's like any building block in the law in a very strict sense. And if we could work with some of the crimes that I think could encompass it, while at the same time trying to move in the direction of amending the International Criminal Code, or putting forward other means by which it could be brought forward, would be at least one step. Anyway, thank you for letting me jump in, Janet.
Thank you. Alex.
Thank you, Janet. So I was actually on the panel that Norm just referred to, that came up with a definition. And I'll say it was enormously complicated, hard to come up with a definition. And within 24 hours of the definition being announced, there were blog posts all over the place saying, oh, this can't work, or it should be this, or this would be better, and so forth. And that was something we anticipated. The idea was to get the discussion going, this little group didn't imagine for a second that it was going to come up with the final definition, because it is an enormously, as a legal matter, for reasons we can't get into now, it's very complicated to come up with the crime and a definition of it. However, the hope is, I think I think this kind of follows on what Norm is saying. The hope is that by starting this conversation, we can encourage states to think about ways that they might amend their laws, or they might focus on environmental crime. I know that at the ICC, Karim's predecessor, Fatou Bensouda, announced that she would consider environmental impact when assessing gravity of crimes. And there are now more and more organizations that are focusing on environmental crime and how to support it, how to foster it. So I think ecocide is, as Norm says, it's probably a long ways off, and it's not itself going to be the answer. But the broader discussion, this is a kind of example of some of the things that some of the panelists were talking about the ripples, about encouraging states. This discussion hopefully will encourage states and state actors and other organizations to focus more on this issue, because I agree with Norm, it's urgent.
Can I throw? Yes, I'd like to throw to you, Karim. Are you picking up this baton?
Well, that's a very direct question, Janet. But what I will say is that I agree really with what Norman said. It is urgent. Unfortunately, as a humanity and politicians, different groups, genocide was only coined by after the genocide. The IMT came after the whole of civilization around the world was ripped to pieces because of the Second World War. One hopes that we'll learn our lesson, but our very existence, respectively as our siblings, shows that we don't, and that's simply a very hard truth. I think there is progress, but the pedestrian rate could, of course, be accelerated, and it may not even be completely in the criminal plane. Of course, as Alex mentioned, the office has a policy of assessing environmental impact as an aspect of gravity. There are certain war crimes that may cause environmental damage that could be prioritized. But I think even in the civil cases, we see, I think it was Mark Harmon, Norman will correct me if I'm wrong, I think he worked with Exxon Valdez years back. We see the BP cases. In the civil, we see increasingly the responsibility that big corporations must have to the environment, and the increasing willingness to for affected communities to engage in litigation to ensure their rights. There was something in Nigeria, of course, in terms of environmental impact. Of course, I won't speak more in relation to the ICCs for state parties to define an offence, and if that offence is enacted, we will prosecute it. At the moment, we've got to make the existing 4 core crimes work properly. We must, make the system succeed there. As Alex said, we must, once we establish proof of concept, maybe we will win enough trust for state parties to look at giving additional responsibilities. But I fear that we may not work with sufficient pace. But in relation to the basic question, the law is not incapable. The beauty of the law is that it can deal with any situation that is essential to the survival of an individual, or indeed the survival of the species, which is what the environmental crimes seek to protect.
Thank you. I'd like to pick up another question from the Q&A. And this one is, I've just lost it for a moment, but it was about whether we can enable victims to find their own voices to pursue justice while they're also struggling with the trauma that they may have experienced, whether in war or in other places. And this has come in from Marion Beckerink. I wondered if some of you would like to speak from your personal experience of enabling and working with victims groups.
If you want me to start. Well, at the ad hoc tribunals, there's no direct participation, as we know, in the proceedings from victims and survivors. But over the years, we had more than 5,000 victim survivors testifying at the ICTY, for example. So interaction with victims is, I think, for every international prosecutor, a key element, because those survivors are reminding us every day why the tribunals for which we are working have been created. And it was mentioned earlier by Karim, you know, if you visit the Holocaust Museum, well, you really understand the gravitas of everything, what happened. And when you are leaving, you still feel it. Well, it is the same when you go to Srebrenica, you meet with the mothers of Srebrenica, and you speak with survivors and victims, and you know that for historians, perhaps those are events which are 25 years old, but for survivors where many of their children are still among those who are still disappeared. For them, it's still the main important thing in their lives, even today, 25 years later. So, yeah, I met probably the victims of former Yugoslavia 30 times, 40 times. It's definitely always the most important moment in my professional calendar. And since I'm not, for the last 4 years, also in charge of the Romanian cases for the Rwanda Tribunal, it is extremely important to meet with victims and survivors. And I don't want to split to a totally different topic, but perhaps if I may, you know, the reason that I'm currently traveling around East Africa is that we still have 6 fugitives at large in relation to the genocide committed in Rwanda. And where we see that even as a UN tribunal, we have still difficulties in securing cooperation, even from UN Security Council member states. And we are a UN tribunal where there is an obligation for countries to cooperate. So you can easily imagine how it is for the ICC with strong support, but not from everyone, how it remains so difficult for all of us to secure arrests and convictions. And this brings me to the victims, because victims, survivors, they want to see persons arrested as soon as possible after the crimes have been committed, and not necessarily 15 or 20 years later, which unfortunately is a reality of many tribunals. So I think one other elephant in the room is definitely the lack of cooperation international tribunals are receiving in terms of cooperation for arrests, or those who are based on voluntary contribution in relation to financial support, because you are sometimes popular as a tribunal today, but perhaps the situation can change a few years later when there are other crises in this world. So international cooperation, I think, is this other important aspect we all need to work on.
Thank you. Peter, you have yourself unmuted.
Yeah, thank you very much. Jenny, I want to give an answer to this more general question. It's a general question that in all our investigations and trials, this is a question for the victims of criminal offenses, how to get a bridge and to work with her trauma of the crime, and especially for war crimes. I want to look on our experience that we have in a special case. I will tell a bit about this case. I mentioned before in my intervention that we had, I think, more than 1,000 women and young girls from the Chesidy people, who was a decision by the German government to bring that, I think, in 2016 to Germany. And these women were tortured by the Daesh, especially with sexual violence. They were enslaved. A lot of Daesh fighters and Daesh men have sexual violence against these women and girls, and also their wives have sexual violence against these women and girls. And so it was for us, the first step to make a bridge to these people, to these girls and women, to get a lot of evidences for our cases. And so we worked together with Chesidy's non-government NGOs, who has a cooperation between these NGOs, and so we started to have a lot of questions to these witnesses, and so first we started with female prosecutors and female police officers to know in a long way with experts, with psychological experts, to ask them what happened with them, what happened in Iraq, was happened in these slave markets and was happened in the families of the IS fighters. And so this was the first step of us to get a very good cooperation with these women, and it was not a duty for them to say what they. It was only on a voluntary base to speak with us. This was the first step, and then I would say that was Serge said. For them, that is not important, so important that the perpetrators get, I think, 20 or 24 years into the prison. They want to have a public tribunal in a German trial or in a national trial or in an international trial, to have the possibility to say in public what happened, to see that the perpetrators were on a court table, in the courtroom, that the international community as well as a German court or national court said, we want to look on this crime. We give you to speak in public, for all German trials are public, to say what happened there and what the perpetrators done in the past. And so when after the trial there is a conviction, so this is, I think, the first bridge to struggle with the trauma of these witnesses, and I think this is a good way to work with them together.
Thank you very much for that. The time has been ticking on, and it's now, I think, time for me to hand back to Klaus so that he can wrap everything up. Before I do that, I just wanted to say there've been some great questions which have come in on the Q&A. I'm sorry that we haven't managed to deal with all of them. There have been some really interesting questions about joint criminal enterprise, specifically about fair trial standards, about whether we will see the crime of aggression being prosecuted again. I think we could continue this discussion for many more hours and still have plenty more to go in depth, because you're all such interesting people to hear from. I'd like to say thank you on my behalf for letting me ask you such direct questions, and just interested to hear all of your point of view. Back to Klaus.
Thank you so much, Janet, for this great moderation and the questions you brought forward. And let me really thank the entire panel for its engagement and the rich discussion we were experiencing this afternoon. It's a relief to see at least you all on the screen together. We don't have to wait until the next Chakokwa or Nuremberg meeting. So technology also has its advantages. And I'm eternally grateful for all of you. Many points have been said. Not all of them have been answered. I would actually permit myself to also throw a question in, and it would go to Karim Khan, simply because he's the only one having jurisdiction over the crime of the crimes, and that is the crime of aggression. We receive, of course, many quests and questions. When is it going to be? When is it going to happen? What can the Academy do? Shall we train national prosecutors on the crime of aggression? And I always say maybe we hold back the horses a little bit and wait for this very delicate phenomenon to arise and give it the time that it needs. And I have a similar view on enlargements of the Rome Statute. As long as not all crimes of the Rome Statute are prosecuted and adjudicated, the question is whether additional crimes would make the situation better, is one that I'm asking myself after 35 years in the judicial system as a practitioner, and then later in the function that I'm now in. So Karim, if you allow me to ask you again, crime of aggression, what's your perspective? What do you think? How can we get it to life? And what can institutions like the Nuremberg Academy do to support that process?
I think there are probably two aspects of your question, Klaus. So thank you for putting it to me. In terms of training, I think training on all aspects of the Rome Statute is to be encouraged, and the crime of aggression is one of the core crimes. training would be wonderful. In terms of when, in a way, that's not my interest. My responsibility is to look at situations within the jurisdiction of the court, to look at the factual matrix and see what has taken place. And then you look at that against the the jurisdiction that we have, and including the core crimes and the crime against aggression. And then, one step follows the next. If we have jurisdiction and the facts are there and the various conditions and loopholes, or hurdles, I should call them, that have been incorporated in the crime of aggression, if those are overcome, a case would proceed. But, my job is really not an activist. My job has to be, as a prosecutor, looking at the facts and then utilizing the tools that I've been given by states in terms of what offences are prohibited. And if the elements are there, we will use the 4 core crimes, and if they're not, we won't. In terms of Nuremberg, all I can say, Klaus, please, with a huge debt of thanks, keep doing what the Nuremberg Principal Academy is doing, which is keeping alive the flame of Nuremberg, being a repository of expertise, and keep spreading it around the world. And that's all we can ask for. Thank you.
Thank you very much. And we will continue doing so, in particular to support your and your colleagues' important work. It takes sometimes a long breath and a lot of resilience. And I wish all of you to have that necessary level of resilience to keep on in all of your work. As I said, I hope to see you all in presence, maybe in Nuremberg, in the courtroom 600, which you see behind me, whenever this challenging pandemic times allow us to go back to meetings. Up until then, the entire thanks of the Nuremberg Academy are with all of you, with all panelists. Thank you so much for interrupting your busy work and looking at your notoriously overloaded schedule to free up time for that discussion. It is an honor and a privilege, and it's also great to have a large number of audience listening to you, and certainly, like me, getting inspired by your spirit and by your ideas how to combat core international crimes today and in the future. Thank you very, very much. I hope to see you all again soon. To the audience, thank you very much for your interest in this event. Please do not forget to register for our next event, with this, our annual Nuremberg Forum, taking place on 15 and 16 October. It's also a virtual meeting, so participation, it's easy. And we will discuss not only the current situation, but the general question whether we all live up to the Nuremberg principles, which had their 70th birthday last year. Last but not least, I would like to thank my colleagues warmly, to Jennifer, to Marion, to Petra, and our technician, to keeping us online here and to keep us all visible. Thank you all very, very much, and I hope I see you again all very soon. Thank you and bye-bye.